of Adjustment. Can we start with the Pledge of Allegiance, please? I pledge allegiance
to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Okay, can we have a roll call, please?
Chairwoman Rosalind Phillip. Vice Chair Michael McDermott.
Present?
Board Member Jeff Mondesir. Board Member Blythe Pierre Lewis.
Present.
Board Member Evan Shields.
Present.
Board Member Marlene Monesteem.
Present.
Board Member Kenneth Each.
Present.
And Board Member Lumana Joseph.
Okay. Gary, you want to read us about the,
I recommend we wait until the applicant is here, and then I'll do it
Oh.
before we call the item, okay?
Is it a requirement that the applicant has to be here?
No, but I understand he or she is on its way.
Okay.
And staff is recommending approval on all three items, just
I have a cutoff, 7:15.
that, so if we're gonna lose quorum and staff is recommending approval,
Okay, let's,
yeah, that's what I was saying, I'd rather do the presentation, and then if they're not here by now, if they're not gonna be
Oh.
prejudiced, if the board is leaning towards granting approval, I'd rather not lose quorum and have the applicant lose
okay,
their.
do you want me to go ahead with the
Yes.
quasi?
Yes.
Sure. Thank you, Mr. Chair.
mhm.
Okay, this is summary of quasi-judicial procedures. These rules apply to applications on specific parcels of land, like zoning variances. The board will sit like a court, hence the term quasi-judicial, reviewing the facts presented at the hearing, applying the adopted rules as explained by staff in the staff report and verbally. Board members can make site visits but must disclose the evidence upon which they intend to rely from that visit. Board members will disclose at the beginning of the hearing whether they have had communications with individuals on behalf of the applicant or otherwise, including who the communication was with and what the topic of discussion was. Persons intending to speak to the board will be sworn by the clerk. The staff will make a presentation. The board may ask questions. The applicant will make a presentation, including expert witnesses, if any, and the board may ask questions. When the public hearing is open, the public can make comments on the application limited to 2 minutes each. Citizen testimony must be fact-based, not opinion. Commission and board may ask questions, and the applicant's attorney, if any, may ask questions as in cross-examination. Members of the public can decline to be cross-examined. The board deliberates based upon the evidence presented. The board's decision must be based on competent substantial evidence, meaning based on the record, staff presentations, expert presentations, and fact-based comments by citizens, according to the standards for approval set forth in the city code. The board may approve, deny, or continue the item.
A point of order, Mr. Chair. I believe that this group should have entertained a motion for approval of minutes before moving to quasi-judicial items. Is that correct, per the agenda?
Mm-hmm.
Wait,
From minutes
the
from our
minutes
February
is
21st
actually
meeting.
item F, and this is item D.
Oh, excuse me.
Okay.
So while staff previously read into the record emailed and mailed comments, we have concluded that this is improper, since the letters are not competent substantial evidence. For example, not sworn testimony subject to cross-examination. The board's decision cannot be based on what is contained in the letters, but they can be used to identify issues and help identify sources of information that do contain competent substantial evidence upon which a decision can be based. Lastly, we ask each of you to treat this proceeding with respect and proper decorum, no calling out, interrupting speakers, or disrupting the proceeding. Please give this proceeding the same dignity and respect as if you were in court. Disruptions are prohibited and enforceable pursuant to the city code. Also, please silence your cell phones. Thank you.
Okay. I guess we can proceed. I guess that's the applicant. So maybe we can do the quasi-judicial oath.
Is that the applicant? Coming. Okay, are there any amendments to the agenda? Okay, you want to do the minutes?
Yeah, okay.
I have some changes to the minutes.
Pardon?
I have some changes to the minutes.
Oh, you do?
I do.
Okay.
Okay, so under communications, staff had included precisely what each board member had said about their disclosures, summarizing it. And I would prefer not to have them do that. So my proposed amendment is to remove the text that's under communications, and in following each title of the agenda items, we would have a sentence that reads, board members made disclosures on their ex parte communications, if any, as required by city code. So just a generic statement
Right.
that
Okay.
the required act was done.
Okay.
So that is my only change.
Okay. All right, with that amendment, do I hear approval of the minutes?
So moved as amended by our wonderful board attorney.
Second.
All in
Include that
favor?
in the minutes.
Okay. Any communications? Staff? No. Nope. Okay. Continued petitions? None. So we start with,
Sorry, sir, the first two items were continued.
oh, they were? Oh, okay, I'm sorry. Okay, so can we have the oath, please? Are you going to be speaking, ma'am?
I'm speaking, yes.
So raise your right hand.
All right. Do you swear or affirm that the testimony and evidence you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
And Lucy, why don't we combine the three items? We'll take separate votes, but for purposes of your presentations and comments, okay? So just make your three presentations. If that's okay with the board.
Yeah, sure. It expedites it a little bit.
Yes, sir.
Good evening.
Read them into the record.
Tonight you're considering three items for the Get Smart Kids Academy LLC. The first is VO224, a variance to allow parking design where vehicles back out into the public right-of-way in the R6 district. The second item is a special exception, SE 1023, a petition for a special exception to use, a petition for a special exception use to allow a childcare center. And the last item is V0324, which is to allow a reduction to the minimum parking requirement for the educational facility for 9 spaces, reducing the parking spaces from 9 to 7.
I just wanted to make sure that we got it right on the record. I think you said for SE 0124, the wrong number. You said 1023.
We're reducing the number from 9 parking spaces to 7.
Okay, the actual number
I
for the
believe that-
special exception.
It's
Yeah,
SE 0124.
Oh, okay, gotcha.
Just want to
Sorry
make sure that
about
was accurate.
Thank you, sorry about that. All right, the first variance, VO224, is a variance to allow a parking design where vehicles could back out into the public right-of-way. The applicant, Mr. Montes, for Get Smart Kids Academy, is requesting to expand the childcare facility to include the subject property located at 1560 Northeast 25th Street. Per the applicant, the expansion will improve the quality of life for his workers, his team is growing, and also allow more resources for the teachers and the students. There's a demand and there's a need for more classrooms in the area. Additionally, he's going to be beautifying the area and adding more landscaping, a playground, and some other amenities for the children. Get Smart Kids Academy was granted a special exception to open their school in 2009 and was granted another special exception to expand their school in 2012. The subject property's primary purpose is to further expand their school because they've grown in the past 12 years. Sorry. Forgot about this. So again, the request the first request is to allow allow a parking design that would allow for backup parking per Article 5, Division 14, Section 5-1401K. This is not allowed. Backup parking is not allowed off of major arterials. This is the location. As you can see, the school is located it's nestled by the existing buildings that are included in the child care facility, as well as adjacent to some existing duplexes. This is a site plan, and on the bottom, you can see there's the green area, that's the playground. There may introduce another building later on into the property, and then you have the where it's boxed in red, that's where the new location for the expansion will be. So during staff's analysis, we felt that the applicant met 5 of the 6 variance criteria. The first is special conditions and circumstances exist which are peculiar to the land, structure, or building involved, and which are not applicable to other land structures or buildings in the same zoning district. We said yes, the building's proximity to the lot line and limited frontage make it difficult to provide adequate parking. However, the approved solution of backup parking is consistent with the area and other approvals for the academy. The second criteria, the unusual circumstances or conditions necessitating the variance request are present in the neighborhood and are not unique to the property. No, the circumstance is not unique to the property. The third one, the requested variance maintains the basic intent and purpose of the subject regulations, particularly as it affects the stability and the appearance of the city. Yes, the requested variance maintains the intent to provide adequate parking and for the proposed use, and will not affect the stability and appearance of the neighborhood. The fourth criteria, the literal interpretation of the provisions of these LDRs would deprive the applicant of the rights commonly enjoyed by other properties in the same zoning district under the terms of these LDRs. And staff said yes, the literal interpretation of these provisions of the LDRs would deprive the applicant of the rights enjoyed by other properties in the neighborhood, and the properties also make use of the other properties also make use of the backup parking. The fifth one, the variance requested is a minimum variance that would make possible the reasonable use of land, structure, or building. And we say yes, the variance is the minimum of the variance. Hold on. The variance is at the minimum will make this land reasonably and make it possible to reasonably use the land, and that's it. The last one is the granting of the variance will be in harmony with the general intent and purpose of these LDRs, and the variance will not be injurious to the area involved. And we say, yes, the variance is in harmony and the general intent and purpose of the LDRs and should not be injurious to the surrounding neighborhood or community. So staff is recommending approval with one condition, that the applicant obtain a CU, business tax receipt, a certificate of occupancy, and complies with all city, county, state, and federal regulations. The next consideration is for a special exception to allow the child care use at the same location. So I'll just jump into the analysis. So in order to grant a special exception, the applicant has to demonstrate compliance with the following criteria. So the first one is that the use is listed as a special exception in the district where the property is located. And yes, pursuant to the LDR's Article 4, Division 2, Section 4-202 of the LDR's list, educational facility private as permitted through a special exception review and is approved by the BOA in the R6 residential district. The second one, there is an adequate provision to assess the facility. There is an adequate provision for access facility adequate for the estimated traffic from public streets and sidewalks so to assure that public safety to avoid traffic congestion, excuse me. Yes, the subject property abuts Northeast 125th Street and the site plan shows pedestrian pathways. There is an adequate parking area off-street loading spaces, if applicable, for the anticipated number of occupants, employees, patrons, and the layout of the car park is convenient and conducive for safe operation. Yes, the applicant has provided a site plan to include the correct, an adjusted amount of parking due to the subject property being an expansion within a current neighborhood and an existing educational facility. The extra parking there will be extra parking adjacent to the property and across the street. There is suitable landscaping or fencing along the lot or rear lot lines adjacent to the residential uses or zoning districts. Yes, the property contours has an existing landscape that will enhance the property, and it has more plantings. The property's special exception is reasonable in terms of logical, efficient, and economical extension of the public service and facilities such as public water, sewers, police, and fire protection and transportation. And the answer that staff said was yes, all basic public services such as public water, sewer, police, and fire protection are readily available and currently serve the property at an appropriate service level. And the two last ones, the proposed special exception will constitute an appropriate use in the area and will not substantially injure or distract from the use of surrounding property or from the character of the neighborhood. Yes, the Child Care Center will provide a service to the community while respecting the desired neighborhood's character. The neighborhood property to the north and the east provide child care service already, and as such a use of a private educational facility may be permitted after review, by the board. So essentially it's saying that this use is allowed, and if it's approved, then it would be able to operate without any problems. And the last is that no open violations or unpaid code enforcement fine exists, and yes, there's none. We've checked that. The last variance before you is V0324, and it's a variance to allow for parking reduction from 9 parking spaces to 7 parking spaces. So pursuant to Article 5, Division 14, Section 5-1402, daycare centers have to have 1 space per 200 gross They have to have enough parking, 1 space per 200 square feet of gross floor area. And when we did the calculation of the gross floor area, we found that they didn't meet that. Instead of them providing 9, they could only provide the 7. So based on staff's analysis, the applicant met 5 of the 6 criteria, and then I'll just read the criteria again in the analysis. So the special conditions and circumstances exist which are peculiar to the land, structure, or building involved, and which are not applicable to the other land, structures, or buildings in the same zoning district. So no, this part of the city consists of smaller lots and non-conforming backup parking exists. Thus, previous approvals have been requested by the applicant for a child care center. The usual circumstance or conditions necessitating the variance request are present in the neighborhood and are not unique to the property. Yes, this part of the community was developed in the 1950s, and it contains many non-conforming structures such as duplexes in the R6 zone and back-out parking. Requesting a parking reduction will allow for the community's nature and character to remain while adding childcare use to this property. That the requested variance maintains the basic intent and purpose of the subject regulations, particularly as it affects the stability and the appearance of the city. Yes, the requested variance maintains the intent to provide parking for the proposed use and will not affect the neighborhood stability and appearance. Non-conforming parking exists already in the area. And the last three. The literal interpretation of the provisions of these LDRs would deprive the applicant of the rights commonly enjoyed by other properties in the same zoning district under the terms of these LDRs. And we say yes. The literal interpretation of these provisions, the provisions of these LDRs would deprive the applicant of the rights of other property owners in the area, and these properties already have backout parking. The variance requested is the minimum variance that would make possible the reasonable use of land, structure, or building, and we said yes, the variance is a minimum variance that would make reasonable the use of the land. And the last one is the granting of the variance would be in harmony with the general intent purpose of these LDRs, and such the variance would not be injurious to the area involved, and we said yes, the variance it would be in harmony with the general intent and purpose of the LDRs and should not be injurious to the area. And I apologize, but I did not express that for this special exception, staff is recommending approval with the following conditions. The first one is that the use complies with all the applicable requirements of Miami-Dade Fire Rescue Department, other county and state approval agencies. Approval of the special exception shall be deemed to authorize only the particular use for which it's being issued and shall entitle the recipient to apply for a building permit or any other approval that may be requested by these LDRs, the city or the region, state, or federal agencies. 3, that the certificate of use of business tax receipt from the Development Service Department will only be issued upon compliance with all terms and conditions of this approval, and the same subject to cancellation upon violation of any of these conditions. And the last is that the application for a business tax receipt or building permit is necessary to establish such a use would be made within 1 year of the date of the special exception approval. And then for variance VO3-24, staff is also recommending approval with the following conditions. The first one, that the applicant obtain a conditional use permit, building permits, and all necessary licenses prior to construction of the building, which is existing, prior to the commencement of the renovation. It should put, the applicant must contain a CU business tax receipt as well as comply with any other applicable LDRs. And the last one is that the applicant will provide a detailed site plan drawn to scale, including dimensions, indicate lot size, street right-of-ways, the pavement measurements from the center line, size of buildings or buildings, interior floor layout, uses, location and size of recreation or play areas, location of fences and or walls, that such shall enclose recreation and or play areas. Said plan shall include but not be limited to off-street parking areas and driveways, walls, fences, sides, and landscaping as part of the building permitting process. And this plan will be reviewed by the Development Services Department as part of the permitting review. And that would conclude my report.
Okay, thank you. Would you like to say something, sir?
I would, thank you.
Thank you, Ms. Watson.
Name and address?
Hello, my name is James Montez. I'm a current resident of the city of North Miami, as well as our business. Our business address is 1565 Northeast 125th Street, which is right across the street from the subject property. Thank you, board members, for the opportunity tonight, coming out and hearing this. As I said, my name is James Montez. I'm here with my wife, Maggie Montez, who we operate the business who we started roughly 16 years ago in the city of North Miami. And we're very proud of serving our community here and living here as well in North Miami. Ms. Watson summarized a lot of what we want to do very well, so thank you for that. But one of the things that I wanted to mention is as it relates to a lot of the conditions for these variances, we started the business in 2000, and we expanded shortly after we opened the initial business, and we went through this variant request to the Board of Adjustment 2 times prior. And I think it's important. We were accepted, thankfully, with all these exceptions, and we've operated within the confines that we're petitioning today in 2 other buildings, and that's how we've expanded successfully. And during that time, operating in the city of North Miami, we've had no incidents at all related to backup parking complaints from our neighbors. In fact, we've actually beautified that section of that corridor from when we originally purchased the property and business. And so we continue with that same intent with this new expansion of improving and going through the entire process that we know we have to go through. And we certainly feel confident that we'll meet the conditions that Ms. Watson discussed in her presentation. And you know, our intent today is obviously to get your approval, and we hope you agree that we want to make this happen, and we appreciate the time.
Okay, thank you. I don't see any public here, but, oh, yeah, it's on, yeah. But of course, it's open for public comment, and seeing none, we'll go to the board members. Mr. Shields, any questions or comments?
No questions, comments from me?
Marlene?
None for me.
No, I don't have any questions.
Okay. Steve, do I have
Nothing.
them?
No, it's the nicest property on 125th Street, I gotta tell you that.
Yeah.
It is, and I think it would be, I think it presents obviously a great opportunity to expand your business, and I appreciate that staff has recommended all 3 passage, of course, with certain
So we'll do.
recommendations.
So we'll do each one at a time? Okay.
On the third item, we need a clarification on the staff recommendation as to the requirement of a conditional use permit.
And also the first item, it is also inclusive.
Oh,
No,
it's-
it does not need that condition.
Okay, so on your staff reports for both variances, there is a recommendation for a conditional use permit. Staff is striking that from the conditions of approval.
Okay. All right, so, as to V0224, do I have a motion to approve?
So moved.
All right, we have a motion and a second. All in favor, say aye.
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 In SC-01-24, do I have a motion?
So moved.
Second.
All in favor, say aye.
Aye.
And under new petitions, V-03-24, do I hear a motion?
So moved. Second.
Okay, all in favor?
Aye.
Okay. Thank you very much.
Congratulations.
Congratulations.
You guys do a nice job.
Yeah. Is there any old business to come before us? Staff?
No, we do not have any old business.
Okay. And no new business?
Well, brief point of personal privilege. I know that one of our board members, you still have to go in 60
Oh,
seconds.
go ahead.
Okay. If through the chair, if so allowed for just 2 minutes.
Sure.
Okay. So I just want to go on the public record with, a couple of thoughts on what I believe was a probably the most controversial set of opinions that we've ever issued as a board, and I'm talking in specific. I won't even mention the exact numbers. I mean, for the public, you know what they are. It's both of the BZ zone projects, the Alta condo development project and Continuum development project in the BZ zone. And those were in October and February, and we voted as a board generally in favor. And certainly not meaning at all to criticize staff or the applicant or a community or even us as a board, but I think in general, there's a pretty general consensus, from my opinion, from staff and the community and us as a board even, and our city council, that there could be a loophole interpretation of our, city code involving the Board of Adjustment's role in height variances. And I know that there are many interpretations of that even since our board meeting and council and the appeal that happened just a few weeks back. I'm personally of the opinion that, you know, we have voted on height variances, at least since I've been on this board, albeit not as controversial. I think there was one time where we voted to add a story, I think, to a 1 or 2 story building, but certainly not as controversial as those. And when we've got something of that nature, it requires robust community input regardless. And I think the text amendment process is that best process moving forward for items like that. Obviously going through the planning commission, public input, and going before city council. That said, I'm not sure if we have the power, I hope we do, but I'm not sure if we have the power to suggest any changes to our council in our code. But if we had that power, what I'd recommend is that our Board of Adjustment be capped in its ability to recommend height variances. My personal opinion is I would like to see that cap at maybe no more than 10% of what's allowed as of right in a given zone. But that's my personal opinion. I'm not sure, and I'm not sure staff knows just yet either, because I've suggested this for public record over email, and we're all trying to do research on this and find a way to have the cleanest, most transparent process for community, businesses and developers, and of course staff and other boards across our city. So I mean, that's my personal opinion. I'd love to see us resolve this as a board and maybe suggest something for our council to opine on. I know that staff is doing additional research, but I wanted to just say for the public record what I believe, you know, would be best as next steps, and just wanted to make that clear.
Okay. Staff, you wanted to say something?
Well, if we're still on new business, I did have something to announce.
Okay.
I wanted to welcome our 2 new board members, Ms. Lumana Joseph and Mr. Chief Each. Welcome. Thank you.
Congratulations. New
Motion.
and old or returning, I
To
should say.
adjourn.
Yeah.
Motion
In
to
some ways.
adjourn?
Okay, well, let's see. Okay, anything else? Okay, do I hear a motion to adjourn?
Yes, you do.
A second?
Second.
Okay, all in favor, say aye.
Aye.